Welcome back. Now let us start with the theoretical and the foundational understanding of separation of powers, as much as it is relevant as far as the mains exam is concerned. Now, as discussed in the previous year questions, we are going to follow a very simple outline for separation of powers. We'll first understand its meaning. Once we've understood the meaning, we will understand the broad objectives of separation of powers. Once we've understood as to why separation of powers is essential, which you can use in GS as well as essay, because I do think sometimes essays are asked on constitutional principles. Third, once we've understood this, we look at it from a comparative basis. And when we compare it to other parts of the world, I do believe as far as you compare it to the US and UK, that is more than enough, because these are our two primary counterparts where you have a differentiating system of separation of powers. Anything beyond this is an unnecessary depth as far as the exam is concerned. And then we get into the Indian perspective. When we get into the Indian perspective, we first understand the historical context to this, probably quote something from the Constituent Assembly and understand how it essentially functioned. We then understand how there is a separation. So we look at provisions in the Constitution and practices which support separation of powers. Then we understand how there is an overlap of the branches of the government on separation of powers. Then we understand the principle of checks and balances. And then we finally do a series of Supreme Court judgments on it and how the Supreme Court has looked at it, finally concluding to our opinion on separation of powers. As long as we're able to do these four things, we should be able to answer any question that comes from separation of powers as far as the mains is concerned. So, as I was saying before, there is a probability that you may be asked an essay on separation of powers. An essay on separation of powers or polity is essentially an extended form of a GS answer. So you just need to write more information on the same topic, and there are a certain selected bunch of topics in polity on which an essay could directly be asked. So let's look at it from an introductory point of view. Now, as far as GS is concerned, as long as you know Aristotle and Montesquieu, this is more than enough. You don't need anything else. Now, of course, political science students or students who have studied political theory in their prior educational pursuits would be familiar with Locke's work on separation of powers and other political thinkers as well. But general studies, as far as you know Aristotle as the origin and Montesquieu as somebody who gave a finality to the thought, it is more than enough. So let's start with what we discussed. So Aristotle, in his book called Politics, had for the first time discussed the concept of separation of powers, very primarily saying that any heterogeneous form of government which has a constitution should primarily have three branches: a deliberative branch, a branch of public officials, and a branch of the judiciary. Now, Montesquieu essentially gave a more structure to this, where Montesquieu said that there is a division of political powers amongst the executive, the legislature, and the judiciary. Now, if you're writing an essay, you could probably go a step further and also quote from where is this sourced from. So Montesquieu essentially wrote this in his book called Esprit de Louis, The Spirit of the Laws in English, which was published in the year 1748. Now, Montesquieu, though a French philosopher, had largely based his model on the British constitutional system, as it was the most prevalent in the world at that time, and he had essentially pursued separation of powers amongst the three prevailing branches of the state: the monarch, the parliament, and the courts of law. Because in those days, the monarch also had substantial powers, and of course the courts of law were evolving. It is important to note that the courts of law of Britain in those days and the courts of law as they are today are actually quite different in terms of how they are placed in the context of separation of powers, right? Now, the constitution, as far as India is concerned, essentially gives you a threefold functional division of government powers. The constitution also, in directive principles of state policy, also make sure that separation of powers is an aspirational objective for the government, though directive principles primarily talk about separation of the judiciary from the executive. Now, this is of course because due to the dearth of lower judicial officials, civil servants were often asked and were tasked with judicial duties, as it is even prevalent in some corners of the country, and several laws such as the CRPC and the CPC do give certain judicial and quasi-judicial powers to civil servants. Now, in recent times, the juvenile justice rules, which were notified for public opinion by the Ministry of Women and Child Development, in fact transfer adoption decisions from the courts to the district magistrates. At the same time, it is the district magistrates who essentially issue a certificate of identity to transgenders, on the basis of which they could claim certain benefits or welfare if the government, whether it is at the center or the states, chooses to provide them. So this is essentially a transgression of powers in a minimalistic manner. At the same time, the civil servants, the executive, also has the powers to make certain rules, whether it's in the form of delegated legislation or geographically centric rules in the forms of orders. They essentially have a context to separation of powers. The fundamental principle is that the L, E, and J should be separate from each other. Why? Because it is very important for you to also link separation of powers to the fundamental principles of liberty, which has to be protected by the constitutions of the world and the constitutions of any country, no matter who they are, at all costs. Now, why? So what is the linkage between separation of powers and liberty? See, the executive must not exercise legislative or judicial powers, because if that happens, you would directly threaten the freedom and the liberty of individuals. In this case, you could say the certain amount of rules and certain amounts of powers which are given to the executive under CRPC can often restrain or restrict the freedom and the liberty of individuals, such as curfew, such as lockdowns, such as shutdowns, and so on and so forth. In fact, the Supreme Court has also looked into the constitutionality of internet shutdowns in the Anuradha Bhasin case in 2020, and actually had very categorically said that unless you have a reasonable reason to do so, the freedom to access of internet still remains to be a fundamental right, and you could sort of link it to separation of powers. Secondly, the legislative should also not exercise executive or judicial powers, because this may lead to arbitrariness and hence therefore end liberty. Now, if you understand what this means, this basically means that the legislature should not be involved in the business of implementing laws, because the legislature is not well versed with the dynamics of it, which could often be an arbitrary application. The laws have to be made in an absolutely unbiased manner, and the legislature should also not possess any judicial powers. In today's world, the legislature possessing judicial powers is in fact a very rare scenario. But if you think about it, when we're looking at removing the president or the Supreme Court or High Court judges or certain members of constitutional bodies, these are quasi-judicial processes. And because these are quasi-judicial processes, these are quasi-judicial processes which essentially are performed by the central legislatures. And of course, the process of it is often questioned to be rather arbitrary, which is why initiatives like the National Judicial Appointments Commission through the 99th Constitutional Amendment were essentially initiated, but they were also struck down later on grounds of violating independence of judiciary, which is also an outcome of separation of powers. So checks and balances versus separation of powers. We upheld separation of powers, and the judiciary upheld it for itself, of course, under a matter of great debate and concern. And lastly, the judiciary should not exercise such power, because then a judge would essentially be performing functions like that of a dictator if the judge starts giving you executive orders or legislative decisions, which is essentially the birthplace of things like judicial legislation, judicial activism, adventurism, or overreach. And we've seen several cases in that matter. In fact, when we look at the problems of suo motu, which is something that we would also discuss in the context of tribunals and the judiciary generally in the forthcoming videos, you would understand this to also have a context with separation of powers. And this is enough as far as the introduction is concerned. Now we look at the primary objectives of it. See, the primary objectives of separation of powers are very simple. First, we have to eliminate arbitrariness, totalitarianism, and tyranny, and create a sense of accountability and a democracy in the form of government, which basically means that separation of powers, by separating the functions and giving each branch of the state an individual domain to function, creates a very clear sense of function as to what they have to do, and therefore nobody gets too much power to begin with. Secondly, it also ensures that there is no misuse of powers as such, because the powers are limited, and these powers in India, for example, are limited by the Indian Constitution in the first place. Now, when we talk about India, of course, poetically and theoretically, the people are the ultimate sovereign in the country as enshrined through the preamble. But in terms of jurisprudence and in terms of actual application, the Constitution is the most supreme entity in the country, and it is the Constitution that sort of draws a chart and draws a boundary of exactly how much work would each branch of government be entitled to do, and what are the powers that they would have to essentially execute that kind of work. And any action, whether it is by the legislature, the executive, or the judiciary, which violates the fundamental principles of the Constitution, which later on get recognized as the doctrine of basic structure, would automatically be declared as null, void, ultra-vires, or unconstitutional. Thirdly, it also keeps a check on the branches of the government by making them accountable for themselves. Because if, for example, a branch of government X has to perform function Y, but slowly transgresses into performing function Z, it is also the moral responsibility of the branch of government X to withdraw from performing function Z, so that things are left within a certain amount of accountability. And fourthly, the separation of powers maintains a balance amongst the three organs of government by ensuring that each branch of government gets too much power to begin with, and the power, as much as possible, is equitably distributed. And fifthly, this ensures that if the legislature's primary job is to make laws, over a period of time, when you start doing the same thing for a long period of time, you are undoubtedly expected to get better at it. Which means quantitatively and qualitatively, our lawmaking processes must improve, our implementation processes must improve, the quality of our judgments, the impact of our judgments, the tenacity and the integrity of our judgments must also solemnly improve. This is possible because the branches of the government have been given those specific powers to deal with. Now that we understand the objectives, let's look at it from a comparative point of view, right? And as I said, we should look at it from a UK and a US comparison. You see, the United Kingdom, in a sense, practices a unitary parliamentary constitutional monarchy. Now, what does this mean? This means powers are fairly concentrated in a layer of government. This is essentially a parliamentary form of government where the Council of Ministers owe their responsibility to the elected legislatures. We may not have a written single document called the Constitution, but there are laws which enjoy constitutional status in the UK, and the head of the state of the UK, who's the monarch, is not an elected one, which is why the UK is not a republic to begin with. Now, separation of powers does get applied to the UK, but the fact that UK does not have a single written constitution but has a multiplicity of constitutional laws which are treated as equally as any other law, the separation of powers principle gets extremely diluted when we apply it to United Kingdom. This means if the country's constitution is unwritten, then separation of powers would usually be diluted, because you would not have a single document clearly highlighting the exact roles, functions, and responsibilities of the branches of the government. Which means the next best entity, if you don't have a single constitution, would then become the parliament as the sovereign rule-making body in the UK, and the parliament has the powers to make or break any law, no matter what it is, in the UK. So there is no such thing as a constitutional amendment under 368 kind of an equivalent in the UK. The Parliament of the UK can wake up and essentially eliminate, add, or amend any law, even if it is constitutional in nature. And therefore the ministers of the UK are very vehemently answerable to the Parliament, and therefore you would see a larger system of interministerial accountability to the houses. The judiciary, on the other hand, has always been independent of executive control. It is also important to note that the UK, as I've mentioned it previously in my lectures also, that the Supreme Court of the UK, which is essentially the oldest democracy of the world, is one of the newest Supreme Courts of the world. The Supreme Court of the UK essentially became functional, I think, in 2011. Until then, you had the Royal Courts of Justice, the Chancery Courts, and of course the House of Lords, which functioned in a judicial capacity. But the judges of the Supreme Court of the UK can only be removed on the address of both of the houses if they are found guilty on the counts of corruption. So there is, of course, a degree of separation, and there's a degree of checks and balances, but this is in a diluted form because you don't have a single law guiding it. However, in the US, it becomes slightly different, because the United States has a written constitution and is governed by the presidential form of government, which means that the president would also enjoy a substantial set of powers apart from, of course, the other branches of the state. Now, this concept of separation of powers is very clearly defined under the American Constitution. In fact, if I recall correctly, I think the first few articles of the American Constitution, I think Articles 1, 2, 3 or something like that, very clearly define that the executive power rests in X, the legislative power rests in Y, and so on and so forth. And interestingly, because the UK is a presidential form of government, countries which usually are presidential forms of government would see a wider and a stronger separation of powers. What happens in a place like India is that the ministers essentially are picked from the legislatures, and they belong to the party which has a majority, or a group of parties that have a majority in the Lok Sabha. Though the minister can come from any house, but ultimately the minister has to be from a house, if not at the time of appointment, but within 6 months of taking charge. That is not the case in the US. In the US, the president and his or her ministers in the US are called secretaries. For example, the Secretary of the State of the US is equal to the Foreign Affairs Minister in India. The Secretary of Defense of the US is equal to the Defense Minister of India. Right? So the president and the ministers are the executive authority, where ultimate executive power lies with them, and they're not members of the Congress. The Congress is a collective term for the US Parliament, wherein the Lok Sabha is often called the House of Representatives, and the Rajya Sabha equivalent of the US is called the Senate. Sometimes the Congress and Senate are also interchangeably used, but largely it's a collective term for the US Parliament or the US legislatures. You see, the president also has unquestionable and absolute authority in deciding who gets to serve in his or her cabinet or in his or her entourage, and there are no qualifications as such. And the ministers are accountable to the president only and not to the Congress, which again functionally separates them from the other branches. In fact, the tenure of the president is also fixed and is independent of the majority in the Congress, which means, and as it happened with the ex-president of the US, which is Donald Trump, he came from a different political party than the one which was in majority in the Congress, more specifically in the House of Representatives or the Senate. So there is absolutely no threat to the security of tenure of the office of the president, and it becomes rather difficult to remove the office of the president or to remove the person occupying the office of the president. On the other hand, the Congress, the US Parliament, is the sovereign legislative authority. It consists of two houses, as I said before, the Senate and the House of Representatives. Now, they get to make a certain degree of laws. The president gets also certain implementation powers, and of course, the president, being the US as a presidential form of government, can also have certain overriding powers on the laws which are made by the Congress. And quite often, there could be friction between the two, as there is no political majority play in action. The impeachment of the president, however, can only be done by the Congress, as they tried as far as Trump's case was concerned. Now, there is a degree of accountability, there is a degree of checks and balances. The treaties which are entered by the president have to also be approved by the Senate. For example, the nuclear deal that India and US had. The Supreme Court of the US is a fiercely independent body. In fact, the Supreme Court of the US also has a form of election in place and a very, very rigorous process. The Supreme Court of the US is essentially where your broad principles of due process originated. And in fact, in the most heightened form would you see performances of judicial review to be executed. And the Supreme Court of the US can declare any action of the executive as well as the legislature as thoroughly unconstitutional if found so. Now, to further understand this, the president does interfere in the functioning of the Congress by exercising certain veto powers, as I was telling you about, in the sense that it is the president who decides the final appointment of judges, therefore interfering in judicial powers. The president also has a certain degree of judicial powers, like our president does in terms of pardon and all of those things. Similarly, the Congress also interferes in the powers of the courts by passing certain procedural laws and laws which determine the functioning of it. The Congress can also create special courts and also approves the very appointment of judges, which also come through an internal election process. And the judiciary also sort of keeps a check by performing actions of judicial review and interferes in the powers of the Congress and the president. So this is essentially how separation of powers works in the context of comparative understanding. Right? Now, let's move ahead. When we start looking at now the analysis of how India deals with separation of powers, let's understand this from a degree of a historical context. So, the Indian Constitution under no circumstances in any of the provisions mentions the word separation of powers as such. The closest that we come to is, of course, Article 50 of the Constitution of India. Now, in fact, when we look at it from a constitutional assembly debate history point of view, the Constitutional Assembly debates did get into this. The members of the Constituent Assembly vehemently and rather rigorously debated the concept and the context of separation of powers, and of course got into the details of whether the Constitution should categorically mention separation of powers or not. And the ultimate conclusion of the Constituent Assembly was that if you clearly write the words separation of powers in either of the provisions of the Constitution, it would then make the Constitution fundamentally inorganic and would restrict the evolution of the Constitution in the first place, which means that the Constitution would be incapable of evolving because it would be fundamentally stuck to certain principles which have been mentioned in the Constitution of India. And in fact, one of the members of the Constituent Assembly, Professor K.T. Shah, had proposed that an article called Article 40A should be added to the Constitution, which categorically said that there should be a complete separation of powers. Even though this was in the directive principles as an idea, it would still give enough due to the government to implement it. However, this proposal of Professor K.T. Shah was not ultimately accepted by the Constituent Assembly. And Dr. B.R. Ambedkar, the chairperson of the drafting committee of the Constitution, did understand and acknowledge that the separation of the executive and the judiciary was extremely important, and also said that while they have to be separated from each other, they're also interdependent on each other for the ultimate functioning of their work and their nature of duties in the government. That the legislature, executive, and judiciary cannot function in isolation to begin with, and there will come a point where they would be codependent on certain activities and certain actions that have to be taken. Now we do a simple permutation combination. We're going to look at three very simple things. First, how does the Constitution support separation of powers? How does the Constitution provide for an overlap of the functions of the branches of government? And third, how do we provide for checks and balances? And once we've got the constitutional provisions right, which you have to quote in the exam, you will then be able to write Supreme Court judgments on the larger theory and conclude accordingly. So let's now look at constitutional provisions which support separation of powers. Now you see there are distinctly, we've got to do this in two ways. First, we've got to figure out how does the Constitution provide for distinct institutions and core powers. And secondly, we then have to look at how autonomy and independence has been given to certain agencies. So first, let's understand distinctiveness of the institutions. See, under Articles 53, Clause 1 and 154, the executive powers of the Union and the states have been expressly vested in the President and the Governor, respectively. This is fairly similar to the US Constitution as well. Whereas under Article 245, very clearly the central and the state lawmaking authority to the Parliament and the state legislatures have also been clearly mentioned. Article 245 then also is supported by Schedule 7 of the Constitution, which obviously, as you would know, gives birth to the idea of a union list, a state list, and a concurrent list. And as I was telling you before, Article 50 of the Directive Principles categorically speaks of the separation of the executive from the judiciary in the government structure. And therefore, you would find that the demarcation between the L, E, and J is actually mentioned in different parts of the Constitution. Now let's look at how autonomy is vested. See, for example, Articles 122 and 212 of the Constitution very clearly stop the courts from inquiring into the proceedings of the Parliament and the state legislatures, respectively. Similarly, Articles 105 and 194 also give judicial immunity to MPs and MLAs from anything spoken during their sessions, which basically means that, and this is a problem when we study this in immunities, that an MP and MLA gets absolute immunity from judicial scrutiny for the way the MP or the MLA votes and what the MP or the MLA speaks on the floor of the House. In fact, there is a current matter pending in the Supreme Court regarding the same, and I've also made a separate YouTube video on this, on the immunity loophole, on how it is almost legal to be corrupt as an MP or an MLA in India. Under Article 361, the President and the Governor are also not accountable to the courts for anything that they do in the course of their powers. You would have definitely studied of this when you would have studied immunities as an explanation to Article 14, where all people are not necessarily treated equally before the law, because the President and the Governor discharge certain functions because they are the President and the Governor, and in fact they enjoy absolute immunity for both civil and criminal actions for things that are done in the course of their office. Of course, for things which are done in their personal capacity, the President and the Governor are accountable, and for example, for civil actions in a personal capacity, they're given a 2 months notice. So criminal actions, as long as they're done with their tenure, criminal action can be taken, notwithstanding the statute of limitations which could apply on that specific criminal act. And lastly, Under Articles 121 and 211, the Supreme Court and the High Court judges are also immune from the scrutiny of their conduct in the Parliament or state legislatures. See, you know all of these. We're just adding articles to this so that it's easy for you to separate L, E, and J. And the fact that you quote article numbers definitely gives you a certain amount of brownie points. Now, we understand how there is an overlap between the L, E, and J, right? So things which are against separation of powers per se. And let's understand this from a simple context. The executive and the legislature, the executive and the judiciary, and the legislature and the judiciary. But let's understand this. So first, let's look at the context of overlapping personnel. See, the Indian government is structured in such a way that ministers, as I was talking to you about, is shared between the legislature and the executive, unlike the US. And this is enshrined under Article 75 and 74. In fact, even the president is regarded as a part of the legislature along with the houses of the parliament. I'm sure all of us in our standard books have read that the president is a part of the parliament. The president under no circumstances is a member of the parliament, but the president is certainly a part of the parliament. Then we look at certain overlapping powers as to what is it that sort of is the executive and the legislature, or the executive doing things of the legislature, or the legislature doing things of the executive. Let's understand this. So, very simply, that the powers of the executive are coextensive as that of the legislature. In fact, this is the fundamental constitutional philosophy behind the ordinance also, that the ordinance making powers of the president are coextensive with that of the parliament, and the ordinance making powers of the governor are coextensive in the context of the state legislatures, right? Which is exactly what Article 123 talks about. Similarly, the president's assent is required for passing of certain bills which are proposed by the legislature under Article 111, and the president also performs certain legislative functions such as the proclamation of state emergency, which fundamentally alters center-state relations, wherein you have the powers to make laws for the state upon the dissolution of the state legislatures. Now, of course, it is not compulsory that the state legislature must necessarily be dissolved and when a state emergency is in operation. But if the state legislature has been dissolved, then the president assumes lawmaking powers. And the very idea of delegated legislation is actually based on the conferment of legislative powers to the executive. Now, this delegated legislation is always carried out under the larger context of administrative law, and which basically says that Article 372 and Article 13, which allows for this to exist in the first place. And this happens when you want the executive to essentially favor the rights of the citizens and also uphold the constitutional values by creating certain rules, creating certain orders which uphold the very values which have been enshrined in the constitution in the first place. Also, the Council of Ministers are collectively responsible to the Lok Sabha, again indicating an overlap between the organs. Therefore, one can easily say that there is certainly a fusion of sorts between the executive and the legislative in India, but there isn't a friction as such. There is a fusion but no friction when it comes to the execution of these powers which overlap between the executive and the legislature, and the president or the governor become very important functionaries of executing these overlapping powers. Now let us understand the overlapping powers between the executive and the judiciary. Now when we look at it, let's understand this. So again, your president becomes a fundamental executor of this, where the president has been given certain judicial powers to grant pardon, reprieve, respite, commission or remise to sentences of any person which is convicted by the Supreme Court, and therefore this is under Article 72. The Supreme Court, after being the final arbitrator, can then of course be a judgment given by the Supreme Court can, of course, if it's a criminal, if it's an issue of a criminal act, the president can in fact release a person can reduce the sentence, can dilute the sentence, or give any extraordinary sort of an order on the same. Similarly, if there is an issue with respect to disputes of the ages of the judges in terms of the retirement from judicial office, under Article 124 2A and 217 Clause 3, Supreme Court and High Court respectively, the President performs a judicial act in deciding what is the right way to calculate age. Though convention and rules say that when you're looking at tenures of judges, it's essentially the number of years that they've served as a judge, then at the bar, when they graduated law school, and so on and so forth. But in case there is a dispute, the president and the governor get to do, the president, sorry, not the governor, gets to do this by the constitution. This has been rarely exercised by the president. On the other hand, if you look at it from Article 227, the judiciary also performs certain executive functions, wherein the high courts have been given powers to supervise the functions of subordinate courts within the districts. Now, this is also a degree of unitary form of federalism, because the states play a negligible role in the appointment or the removal of high court judges, and therefore when high court judges are supposed to administratively manage lower courts within the state, and the states are responsible for recruitment of lower court judges, this also creates a degree of accountability. Apart from this, under Article 228, they also perform administrative functions such as the transfer of cases within, of course, state jurisdictions. Now, you don't have to get into the technicalities of it, but the fact that you would know these articles, which are rather uncommon in standard textbooks, already gives you an edge in your answers. And then finally, we of course look at overlapping powers between the legislature and the judiciary. Now, the parliament performs judicial functions such as punishing its members or outsiders for contempt or breach of parliamentary privilege. In fact, when the presiding officers of the parliament discharge functions of anti-defection law and decide to disqualify somebody, that is in effect a judicial function. In fact, there have been Supreme Court judgments which have said that when the presiding officer is deciding a question of anti-defection, it is essentially functioning like that of a tribunal, which is why anti-defection law cases, after they've been decided by the presiding officer of the respected house, could then also be looked into the Supreme Court or the High Court. Whether it's the Ravi Naik's case or the Quixote Solohan's case, both have largely maintained the same line of thought. The judiciary, on the other hand, does perform certain legislative functions, such as laying down rules and procedures for court proceedings and practices. You have the Supreme Court rules, you have internal rules, on the other hand, which are drafted by the Supreme Court under Article 145. Apart from this, when we see applications of judicial legislation, it is essentially in the larger context of checks and balances. So this takes care of the second problem or the second dimension of separation of powers, which is essentially an overlap between the branches of government. And then we now look at checks and balances. Give you some constitutional provisions for this. So, for example, the parliament has the power to initiate impeachments against the president, and of course you require the toughest form of majority, which is more than 2/3 of the total strength. But it is the parliament who removes the very president, who is supposed to perform, in rare occurrences, functions of ordinances and so on and so forth. Secondly, the president and the parliament collectively have the power to remove the judges of the Supreme Court under Article 124 and High Courts under 217. While the actual voting happens under the direction of the parliament, and the president can also initiate or can direct for a very specific committee to be formed. Now, the president also possesses further power to appoint the judges of the High Court and the Supreme Court under Articles 224 and 217. As we would know, it is actually the President of India who appoints both Supreme Court and High Court judges. The oath for High Court judges is delivered by the governor, and the oath for Supreme Court judges is delivered by the president, and this is just a logistical convenience. Most importantly, the powers of judicial review, which is under Article 32, 226 and 136. 136 is special leave petitions, which we will discuss later on, reflects a paradigm shift of checks and balances, wherein the courts have been empowered to strike down laws of the parliament or actions of the executive which are often adjudged to be unconstitutional. Apart from this, the Supreme Court has also been bestowed with extraordinary jurisdiction to do whatever it can to ensure there is justice which is upheld. You could further quote provisions of You could also quote actions of suo motu, which are available not only to courts but also to tribunals. In fact, the larger debate of whether the National Green Tribunal should have suo motu powers in the first place and why do they have is also a matter of debate, which is essentially a function of checks and balances. Now that we understand what the Constitution has to say about this, we must also now look into how the Supreme Court or the courts have dealt with this. There are essentially 4 judgments that we need to know, right? And purposefully, you don't have to worry about the years. In the Ram Javaya Kapoor versus State of Punjab, this is something we discussed in Federalism also. The court has also said exactly what we have. The Constitution does not very specifically acknowledge separation of powers, but through the way things have functioned, through the way provisions have been sort of mentioned in the Constitution, the separation has been adequately distinguished. And therefore, the constitutional structure sufficiently differentiates between the branches of the government. In the reference Delhi Laws case, Delhi Laws Act case, this is again a very old case, it was highlighted how the British parliamentary system, which was adopted by India, entails the responsibility of the executive to the legislature as its essential feature and does not strictly necessarily follow the doctrine. In fact, a largely controversial matter was the Indira Nehru Gandhi versus Raj Narayan case. Now, what essentially had happened here was, if you go back to emergency provisions, is that that you would remember that Indira Gandhi had lost the election, and the High Court had the High Court of Allahabad had upheld the fact that she had that her candidature had to be cancelled. She went on appeal to the Supreme Court, and the Supreme Court said, fair enough, while we decide the final merits of the case, you cannot vote and you cannot adequately participate. You can be present in the houses and you can discharge your functions as the Prime Minister, but you cannot participate actively as a member of the Parliament. And while the court in effect stayed the order of the Allahabad High Court, emergency was declared. And then, of course, the 39th Constitutional Amendment came into being, wherein the 39th Constitutional Amendment restricted judicial review of elections of the President, the Vice President, the Prime Minister, and the Speaker of the Lok Sabha. This fundamentally was on the principle of separation of powers, and the Supreme Court, and this, of course, the 39th Amendment was challenged, and the Supreme Court categorically said that past separation of powers, as it is in American and Australian constitutions, does not apply to India. We do have a separation of power, but it is also conjoined with checks and balances. So therefore, the schemes of the Constitution or the principles of the Constitution cannot be changed just because 368 allows you to do so. And predating the Indira Gandhi case is, of course, the Golaknath versus State of Punjab, which we studied in Amenability of Fundamental Rights, where the Supreme Court had made an observation that the branches of government should function within the authority which has been given to them, and no authority which is given by the Constitution is supreme, but the Constitution in itself is supreme, which is also why in Golaknath's case, the Supreme Court struck down the differentiation between an ordinary law and constituent law, and said that all laws are equal and no law can violate fundamental rights, and you can't touch fundamental rights per se. So we extract our understanding of separation of powers from these 4 basic judgments. As long as you can quote at least 1 or 2 of these, you're fine. See, while separation of powers does make a lot of sense, it does have certain practical limitations, and let's understand this. In a parliamentary democracy, it is extraordinarily difficult to distinguish the powers of the legislative, the executive, and the judiciary. A fluid government, a smooth government, a stable government can only exist if there is a degree of cooperation between the 3 organs, where all of them collectively work for the betterment and the best interest of the people within the country. Any attempt which has been made to strictly separate them into watertight compartments, especially in parliamentary democracies, would definitely lead to the failure or the inefficiency of the government. And while we do get greatly influenced by the US, we must also understand that in terms of functioning, the fact that the president of the US gets such blanket powers is essentially antithetical to principles of democracy. And if separation of powers is implemented in its absolute form, it will be very difficult to take a certain degree of actions, because you would never be able to keep a check on each other, and neither the legislature would be able to delegate lawmaking power to the executive, which actually may have certain subject matter. For example, if you want to draft the mines and minerals rules, or the motor vehicles rules, or the RTE rules, you've got experts in the executive. The executive can hire experts, will also have experts who would help to give you more technical clarity on the broader umbrella of laws that you've sort of made. Nor the courts can make laws relating to the functioning of courts and proceedings, which should be an internal matter. If the parliament is supposed to also make procedures and rules and laws on how the courts have to procedurally function, then the courts will have very little ground to play with. The way the country is today, and we must understand that India is essentially a welfare state, the ultimate objective is to make the lives of the people better. And for that, certain issues in society have to be resolved, and these are very complex issues. And in such circumstances, the principle of separation of powers is impossible. If you want the judiciary to strike down, to evolve, to give interpretations to the constitution, take the case of the Puttaswamy judgment, where right to privacy has been recognized as a fundamental right under Article 21. Now, this has been a very, very important catalyst in evolving our policies on homosexuality, in moving towards a nation which is now actively discussing privacy. Of course, data privacy also, for that matter. We are now actively discussing marital rape, because these are notions of privacy. The fact that we're able to move towards discussions like these, towards an evolution like this, is because separation of powers in its absolute sense does not apply. If there was separation of powers, then right to privacy would have been a rather more difficult or a slightly unlikely idea. And therefore, you would never be able to implement the objectives and the functionalities of what is called the modern state. And therefore, the separation of powers is theoretically improbable, and of course is practically impossible. It is just undoable to actually do this on a day-to-day basis. So Montesquieu, while propounding this theory, essentially wanted to protect the freedom and liberty of the individuals, and this cannot happen through a strict enforcement of separation of powers. So what is the Indian structure, and what should our final words on separation of powers be? So the Indian structure is something like this. You've got core powers of the legislature, the executive and the judiciary, and these core powers function in their own spheres. All of these, through principles of administrative law, overlap, and therefore there are certain interchanges, and because they do perform similar functions, there will always be incidental overlaps. So the doctrine of separation of powers must always be implemented and must always be interpreted in a relative form. We live in the era of liberalization, privatization, and globalization. We require the organs of the state to work together to evolve policies. This should not be done as a method of restricting power or as a method of strict classification, but it should be done in the spirit of cooperation, coordination, and the interest of the welfare of the state. Now, if you're able to do this, if you're able to write answers like this, I assure you, you will not have a problem with separation of powers. I know this takes a lot of research, and my job is to give you the best content and tell you how to deliver the best content. And I appreciate the patience that you've shown on this. But don't worry, got your back on this. We finished this, and now we move to the other parts of the third topic, which is separation of powers. Thank you, and stay tuned.